All right, so we ended with this slide on federal judges who are nominated by the president or the executive, and they're confirmed by the Senate. This extends to, everybody from the Supreme Court justices all the way down to local district court justices. There are various ways, or there were in the past, where the Senate could block such nominations. But things are changing. There used to be a filibuster, meaning that you had to get 60 votes to advance a nominee, but that's gone. We talked about Merrick Garland, and the most important thing here is to note that federal judges have life tenure. They do not have to retire, but they can choose to. And many judges make that choice when they think that the executive is likely to appoint somebody to the position who they think is appropriate. Let's advance the slide if we can. Oh, there we go. Obviously, the Supreme Court is one of the most influential powers that the executive has. When he or she chooses a nominee, they're looking at the likelihood of passing the Senate, the qualifications of the nominee, the attitudes towards policies. So, for example, there's something called the Federalist Society, which is a very well-established society of law students, young lawyers, judges, lawyers, who take a fairly conservative approach towards policies and changes in the law, and they kind of cultivate nominees for the Supreme Court, so that when a president chooses a nominee, they put forth a list of possible choices, and depending on what the executive wants to do, they might choose from that list. Reward. Is the executive rewarding somebody or something for support? If the executive chooses somebody who is, very hostile to the right to bear arms, does that create a political reward for the executive among people who are opposed to the Second Amendment? If the executive appoints somebody who's skeptical of the precedential value of Roe v. Wade, does the president receive a reward politically from people who would like to see that precedent revisited? So there's lots of factors that go into how an executive chooses a nominee. The Senate is supposed to advise and consent, but it's very unclear what that means. Do they have to consent? Can they refuse to consent? It really depends on who's in power in the Senate. Same factors for nominees exist at the lower courts, although the reward issue might be actually more predominant at the lower courts, because you can kind of get, you can kind of curry favor more easily with less scrutiny at the lower levels. A turning point happened in 1987 with Robert Bork, and that kind of created a whole cascade of opposition to president's nominees when the Senate is controlled by the opposing party. And that's been going on ever since. We saw that with Merrick Garland. There was a tremendous amount of opposition to President Trump's nominees, but the Democrats weren't in power in the Senate, and the Senate had canceled the filibuster, so the Democrats could not block President Trump's nominees to the Supreme Court. One big question is Justice Breyer, who's very old, and may consider retiring soon, because if he retires now, President Biden is in power for 2.5 more years or so, and President Biden would be likely to nominate his successor. Question for you is to think about: does Breyer choose to retire before the midterms, when his party is still in power in the Senate? If he chooses to retire after the midterms, could the Senate, if it's in the power of the Republicans, could the Senate block President Biden's replacement for 2 years? State court judges are different. There are different ways that different states select their judges. There are 5 broad categories. The first one is gubernatorial appointments, which are nominations by the governor. And usually the state Senate or the state kind of legislative body will confirm. Then there are legislative elections, where the state legislatures elect judges. Partisan elections are where voters choose between nominees, and the nominees list their party affiliations on the ballot. That means that if someone's running for an open judgeship, they say whether they're a Democrat or a Republican or independent. Nonpartisan elections is just they don't put that indication on the ballot. And then there's something called the Missouri Plan, which is a commission which is established to nominate candidates. The commission then will contain lawyers or non-lawyers nominated by the governor, lawyers nominated by their colleagues. And the commission makes a list of nominees that the governor chooses from. Why do you want non-lawyers? Well, there are a variety of reasons. One, maybe you want business people or local, educators or politicians even. There are all kinds of reasons why you might want people on a commission who would bring a different perspective to the nominating process. If it's just lawyers, you might get into an echo chamber where the same ideas and the same educational background dominate on the judges. And judges are the primary ways that the public interacts with the judiciary, obviously. So it's not always the best idea to have kind of an echo chamber in the nomination process. The same way that the nomination process differs by state, the length of state court justices' terms varies. In some states, they have a fixed term, 6 years, 4 years. Some states, they have a mandatory retiring age. Now, question whether or not you want a mandatory retiring age. Is it appropriate to require judges to retire at 70, 75, 65? Yes or no? Is there a value to having continuity on the bench? Or is there a competing value to having new blood, breath of fresh air on the bench, younger, perhaps more tech savvy, perhaps more socially aware, who knows, younger judges. Liberals tend to favor the Missouri system. Conservatives tend to favor elective systems. Interesting, that suggests that conservatives would like to have more public impact and more public involvement in the selection of judges. Most of the time when a judge runs for office, it goes uncontested. We already talked about the fact that judges don't make anywhere near as much money as many lawyers do, and there's a lot of work. A lot of work. You're hearing cases, you're dealing with parties, you're dealing with all the administration of your courtroom. And if you're the incumbent judge, it can be very expensive to run against an incumbent judge. When the elections are contested, there can be quiet elections where there's not a lot of publicity. It's just two local individuals running. Or there can be noisy elections where the interest groups and other local groups or national groups will pour money into these contests. Why would they do that? Perhaps they want a judge who they think will be favorable to their industry or their causes or their policies. One thing that we'll get to later in the semester is something called liability caps, which is where certain industries or certain claims have a cap on the amount of money that can be awarded as damages. The idea being that you want to create an environment in your community for business or for, types of policies because they serve a social purpose. They employ people. They provide a good, basis for tax revenue, whatever. And those businesses might be more attracted to places where there are liability caps. They're not going to be worried about getting sued and getting a multi-million-dollar damage award. Issues like soft on crime, hard on crime. I'm a former prosecutor. These are all kinds of things that can go into judicial elections. Do you want a judge who's been a former prosecutor or a former defense attorney? All kinds of interesting issues can go into the makeup of the judges. Now, when a judge dies midterm, there can be all kinds of different processes, or a judge retires midterm to fill the role until there can be election. One of these processes is called an interim appointment, which is in most states with elective systems. That's where the governor might appoint somebody to fill a role until there can be an election, and that, as we've heard, goes into concerns that judges have about if and when they choose to retire. Who's going to fill their role until the election, if there is one? In states that appoint gubernatorial elections, I'm not going to read all this because you guys can read just fine, and this is in your book as well. but they're all this kind of covers the various processes for the appointment of judges. Obvious question is, who chooses the commissions who nominate the people to be judges? Usually there are nominees who come from the governor, but then there are nominees that come from a different body as well. And that's because if all the nominees came from the governor, it'd really be the same thing as the governor picking the judges. When there are nominees from other commissions or other bodies as well, that preserves the power of the commission to not be sort of stuck with nominees that just come from the governor. Compare that to a case in Florida where at the time Jeb Bush was the governor, and a rule change let him choose all the members of the nominating committee. That basically was tantamount to letting him choose everybody who could be appointed to be a judge. One issue is, what is a retention election? Usually in a jurisdiction or a state where the governor appoints judges based on judges that come from a list, those judges can be recalled, or they can be put up in front of the voters to see whether the voters want to keep them or not after they've been appointed. That kind of election is called a retention election. And usually a simple majority of voters will be enough to keep a judge on the bench. But as we've seen, almost always judges win unopposed retention elections. You've got to be a judge who's done something pretty bad, and there's been enough publicity around that for you to get kicked off the bench in a retention election. What system is used? There are similarities. One of the main ones being that in state courts, the governors have a great deal of influence. They choose the nominees, they can fill the vacancies, and as I said, judges often stick around for quite a long time. Folks who like the Missouri plan say that it gives the best quality nominees, but the data suggests, at least the data in our book, that most systems produce similarly qualified nominees. Why? Well, because probably nominees for judges tend to come from a pretty similar pool. You have to be a lawyer usually. You have to be practicing for a while. You probably have experience. You probably know all the players, and there's just not that wide a pool, or that deep a pool of possible nominees. But one issue is that you might get a different kind of judge depending on the way the judge is chosen. If it's an election, there might be reason to get somebody on the, someone who wins an election oftentimes is good in front of the public, is outspoken, is well known for certain positions, and then may feel as if they are bound to those positions. If you run on a policy of being strong on crime, or being opposed to medical marijuana, or whatever else, then once you're on the bench, you're kind of hamstrung because you're expected to behave that way. But if you are someone who has not had to take those positions in the nomination process, you might be able to not be sort of anchored to those positions. And once you're on the bench, if you've been someone who's been elected, oftentimes you have benefactors, you have people who have voted for you have people who've given money to your campaigns. They may expect you to behave a certain way. They may even expect you to treat them a certain way, in which case that puts pressure on people who have been elected. The other issue, though, is that if you are subject to elections, you are cognizant of what the community is in favor of and not. You have to take into account not just the law, but what is happening within the community, which may result in you thinking a bit more carefully about your role on the bench and your role in the community, and that might not be a bad thing for a judge. Stop here, and I think we have one more voiceover to get through, and then we'll be done with this section of our textbook.